Are you both free to marry? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. In today's video, we're going to talk about marriage-based green cards, and we're going to talk about one little aspect of those cases, and that is whether or not both parties are free to marry. Now, when you file for an immigration benefit like a marriage-based green card, it is your responsibility and your burden, your legal burden of proof to demonstrate that both you and your spouse are free to marry. Now, of course, in any marriage-based green card case, we have two parties. There's the U.S. citizen and the non-U.S. citizen. And so that could be a same-sex couple, it could be a heterosexual couple, it doesn't matter as far as what we're talking about. What we're talking about, though, is are each members of the relationship free to marry? And of course, if no one has ever been married before, if neither part of the couple have been married before, then they are both obviously free to marry as long as they're old enough and of sound mind and those kinds of things. That's not what I'm talking about. What I'm talking about are prior divorces or prior annulments. So of course, if you're applying, you have to show that on the day that you got married, that you were free to marry. And you wouldn't believe the number of times this has actually come up at Hacking Immigration Law. We've had probably 30 or 40 cases where one of the parties' ability to actually legally get married became a big issue in the case. That's why we're shooting this video. So when you apply for the marriage-based green card, you're going to have to prove and satisfy that burden of proof that you're both free to marry. And that means that if there have been prior divorces or if there have been prior annulments, that everybody is in agreement that the judgment of divorce or the judgment of annulment were entered properly. And so what that means is that you're going to have to prove that the final order, the final judgment was entered in your favor. And again, on the day that you married, that the prior divorce was final. I've had cases where people got married and their divorce got finalized after the fact. And I had to tell those people, hey, for purposes of immigration, you're not legally married. You need to go back and get re-divorced or finish the divorce or just get married again if the divorce was already final, but it happened after the prior marriage. So people are left scratching their heads and they're saying, well, Jim, how can we get married if we're already legally married? Well, of course, the answer to that is that in most instances, you weren't legally married because you weren't free to marry. So the timeline here is very important. And that's why whenever I talk to people about prior marriages, we really want to do everything we can to nail down the prior marriage. It's not so much whether you got into a relationship with your current spouse while you were still married. We can usually deal with that and, ideas of adultery and things like that. That's not the issue. The issue is the timing, whether your divorce was final and then some time passed before you got married. Now, it could just be a few days, but the divorce has to be final. So sometimes people are separated, sometimes people have filed for divorce, and then they've gone ahead and gotten married, and that's a real problem. In fact, it could be an extra problem. A lot of my clients come from the Middle East and from predominantly Muslim countries, and I could see an argument from a USCIS officer that not only were you not legally married, or they could flip it on its head and say, hey, you married two people at the same time, you're bigamous, and that's polygamy, and that's a bar to getting a green card. And so that could be a whole other issue. But what I really want to focus on is making sure that you nail down that divorce decree, and you do that best by getting a certified copy of the divorce decree. Now, we would get the entire divorce file because you always want to see what's in there in case the government goes a-looking. But if you just get the certified copy of the judgment of divorce, the final order, that's what you need. And that's true with the annulment as well. You're going to need to get a certified copy. Why do we get a certified copy? Because USCIS likes this issue. This is a very clean issue in which they can deny a case. And of course, don't forget, USCIS is always looking for a reason to deny your marriage-based green card case. And this is an easy one, because if you got divorced 3 days after your marriage, or if you never got divorced, or if your divorce was messed up somehow, and they can show that you weren't legally free to marry your spouse, then they can deny that immigration benefit. That's the kicker, and that's what we're trying to avoid. That's why we made this video, because we want you to make sure that you have a clear look at the divorce decrees. Make sure that it's certified. Certified means that you paid a little bit extra, and there's a certification attached to it from the court so that USCIS can be confident that that divorce decree is valid, that you didn't just print it out on Amazon paper, as an officer once claimed to my wife, Amani, that this divorce decree looks like it was printed on Amazon paper and it was really from overseas. That brings up the issue of overseas divorce decrees. Now, With U.S. divorce decrees, generally, USCIS is going to take those if there's a certified copy and if it's documented that you got this from the correct court. Where we really see a lot of problems are overseas divorce decrees. Now, don't forget that the State Department has gone through what's called the visa reciprocity table. And so if you're trying to use a divorce decree from a foreign country, you really, really need to check the State Department's visa reciprocity table to see what description the State Department has come up with as to what your divorce decree should look like. That's the thing. The State Department's rules govern. What the State Department says about what should or should not be on a certified divorce decree from overseas is the magic touch. It's what you need to get your case approved. If yours doesn't match what the State Department says, you're most likely going to get a notice of intent to deny or request for evidence. You're going to have to prove up that this is a valid divorce decree. So if you're using foreign divorce decrees, you need to make sure that it matches what the State Department says should be available, that it's from the right court, that it has the right color seal. It's very detailed in what they provide and what you need to provide when you get that certified copy from the court. Now, the one other reason I wanted to bring this up is because right now, foreign divorce decrees, especially from the nations of Ghana and Nigeria, are really under attack at USCIS. USCIS, I believe, is operating from the assumption that every single divorce decree they receive from Nigeria is fake unless proven otherwise. And then as for Ghana, that most divorce decrees are considered fake until proven otherwise. So you're going to have extra work to perform. If you have a divorce decree from one of those jurisdictions, you're probably going to need to independently check with the court, not with the lawyer who handled your divorce, but with some other independent person to go to the court to see if your divorce was final and if you can get a certified copy, because that's what the State Department's going to do. That's what USCIS is going to ask the State Department to do in order to go check to see whether your divorce decree is final. So if you have a foreign decree, you really need to make sure that it's the right kind and that it's generally accepted. Now, these are the kinds of things you might not know if you're not in our world, if you're not dealing with immigration issues every day. This is the kind of thing that the value that we provide in working as your immigration lawyers. We've been seeing this issue over and over and over. We know how to deal with it. We know how to set you up for success, because what we don't want is for you to file an I-130, to get your fingerprints, to have that long delay of months and months and maybe even years. And then at the end of the day, you get a denial because that divorce decree wasn't valid, wasn't final, and that you weren't free to marry. We're seeing more and more of it, and that's why we wanted to warn you. If you're thinking about hiring us to help you with your green card case, if you got married to a U.S. citizen and you want our help helping you get an immigrant visa or a marriage-based green card, we would love to help you. It's one of our favorite cases to work on. You can give us a call at 314-961-8200. If you want to email us because you're thinking about hiring us, that works too. You can just email us info@hackingimmigrationlaw.com. Now, if you're the kind of person who's thinking you're going to do this on your own, and of course, if you have a messed up divorce decree or marriage situation, I would encourage you not to do that. But if you are, we have some free resources for you as well. We have our YouTube channel with now hundreds and hundreds of free YouTube videos where I'm giving out some of my best information. We also have our Immigrant Home Facebook group where you can join and talk to other people going through the immigration process. And then finally, we have our Immigration Answer Show, which I do 2 or 3 or maybe even 4 times a week, where I answer as many immigration law related questions as I can. And we do that all within 1 hour, and that's totally free. We'd love to hear from you. Otherwise, give us an email, shoot us a call, anything that we can do, and we'll be happy to help. Thanks a lot.